Hello, my name is Michael Massman. I'm an attorney with Neighborhood Legal Services of Los Angeles County. This presentation is about answering the complaint, and most specifically, a complaint in a credit card collection action. We'll also discuss alternate strategies that one could employ, but the primary focus of the presentation is how to answer the complaint. The presentation is meant to provide information only. It is not legal advice. If you need legal advice, you should talk to an attorney about the specifics of your own individual case. So first of all, let's talk about when filing an answer can help. And we'll talk about when it doesn't help in a little bit too, but let's focus on when it does. So first of all, if you're being sued by somebody to whom you don't owe the money, if you're a victim of identity theft, if even part of the charges are the result of identity theft, if you've already paid this debt, then these are all legal defenses to the credit card collection action. And filing an answer absolutely makes sense. Another reason one might want to file an answer is to buy more time, and that could be more time to file bankruptcy. It could also be more time to put together enough money to offer a settlement package that might work. So again, having a legal defense or needing time are good, valid reasons to file an answer. A reminder, I talked about this a little bit in one of the prior presentations, that you have a limited time to file an answer. If you were served personally, that means you've got 30 days, 30 calendar days specifically. If you were served by substituted service, which is where instead of handing it to you personally, they mailed it to you, then you've got 40 days from the mailing date. These are calendar days, which include weekends and holidays. And that's important because if you miss these deadlines, then the other side can go to the court and request a judgment without you ever having had an opportunity to assert a defense. So you may not want to file an answer, but if you do, it's important to know that there are deadlines that apply. So let's talk a little bit about when it may not help. So if you don't have a legal defense, then generally speaking, that's not a great reason to file an answer. Sometimes you can end up paying attorney's fees if you fight a lawsuit and lose. So fighting without a legal defense it can work against you. If you're filing an answer to tell the court that you suffer from an illness, that you have a job loss, or that you're unable to pay but you intend to pay, these are not really reasons to file an answer, and there are other ways to talk about these or to bring this to the attention of the court. But when it comes to making a decision about whether or not you owe the money, the judge is only allowed to consider legal defenses. So putting in an answer to assert illness or inability to pay or job loss or such is not, generally speaking, is not a good strategy. So the good news is, unlike a lot of other documents that you might file in court, you don't have to draft it from scratch. You don't have to write it up. The court and other organizations provide forms that you can use to answer. And this makes it easier. So there are up to 5 potential forms to fill out, the answer form itself. Then there's an attachment that you can use to the answer form, which is a checkbox that will allow you to assert defenses. You're going to need a proof of service form. This is a sworn statement made by somebody who's not a party to the lawsuit, that the answer was served on the other side. So you need, if you're the defendant, you can't mail it yourself. You need to ask somebody else who's an adult to mail that and then sign this form as proof that you mailed it to the other side, and you're going to need to provide that to the court as well. The other side has a right to know your defenses, just like you have a right to know the allegations against you. And then finally, you can also ask the court for a fee waiver, and to do that, you fill out a fee waiver request and a fee waiver order. These forms are available online through the courts. But if you have any trouble locating them, you're certainly more than encouraged to reach out to us to help you find the forms and for help in completing them. So this is just a screenshot of the answer form. You see that on the top there, you list who you are or who your attorney is and contact information. You put where the court is, identify the parties, and list the case number and such. You just kind of got to work through forms like this slowly. These are screenshots of attachment 4. Again, this is a checkbox, but a check line more specifically, and it's helpful in that you don't have to go doing a bunch of research necessarily. A lot of the common defenses are here, and we can help you to fill this out as well. So one common defense that I like to bring to people's attention is what's called standing and privity. This is going to apply in a situation where you're being sued by a debt buyer that is not the person with whom the defendant had the original contract, not the credit card company. And one of the reasons I point this out is because it's a valid defense, but also because it's got some legal jargon in it that you might not recognize. So on attachment 4, this is represented as standing or privity, and you can think of standing as an injury and privity as a relationship. And so the defense kind of relates to this slide we have here, which the debt buyer buys the contracts, but they never sign the contract themselves. So the argument you're making is a little bit like, I never signed a contract with this person, so therefore I don't have privity with them, privity being a relationship, and therefore they're not injured, therefore they don't have standing to sue. And so again, it's got some legal language in it, but if you're being sued by a third-party debt buyer, this is a valid defense worth asserting, and you're also welcome to reach out to us to talk a little bit about it. Some common pitfalls to avoid after you answer. So this is in here, it's important because an answer is really just the beginning of a lawsuit. There's a lot more work to do after that. The next step that the other side might do is send you discovery requests. Those can come in the forms of requests for documents, open-ended questions that you have to answer, or requests for admission, simple statements that you either have to admit, deny, or say you have the inability to do so. Missing a court date can also get you into trouble. And then even after the lawsuit, if you lost the lawsuit and they are trying to collect, not asserting your right to protect your income, protected income such as Social Security, it can be a problem. So if you did lose the lawsuit, getting a little ahead of ourselves now, and somebody's trying to take your money, then it's important to assert what protections you do have. And again, you're encouraged to reach out to us about that. This is just a simple reminder of some alternatives to bankruptcy, or not to bankruptcy rather, but alternatives to the lawsuit and putting in an answer and litigating it. Filing a bankruptcy might be an option. Negotiating a settlement could be an option. Sometimes, if all of your income is protected and you just don't want to deal with it, like perhaps you're retired, you don't expect your income to change. There may be other circumstances. You can send them no contact letters and letters explaining that your income is exempt. If you tell them that you do not want to speak to them about this debt, then they're obligated to respect that by law. And again, just a reminder of exempt income. That exempt income is income that even though somebody else has a judgment against you for tens of thousands of dollars, they can't touch. That was covered some on another slide. It includes things like Social Security income, retirement benefits, income that's less than the minimum wage. So if you have questions about that, you're encouraged to reach out to us. You see here a link to our website, contact information. If you go to our website, you can fill out our self-help questionnaire, and that'll get the process started. One of our paralegals or intake screeners will reach out to you. Thank you very much for your time and attention. I hope this presentation has been helpful.